Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, late last week, we got a ruling out of the Second Circuit in a stun gun case out of New York City. Now, the ruling was a terrible ruling, and it had a lot of people flipping out. But one of the reasons that many people were flipping out may, well, actually be incorrect as well. So we kind of have double wrong going on here. We got a court that totally screwed this up, but we have a listening audience that I think also misinterprets other Supreme Court precedent. So we're going to try to clear all of that up. We're not going to stand up for the ruling because it still sucks, but today we will get you educated. So let's spend a few minutes and let's talk about why everybody is wrong about the New York stun gun case. Okay, America, this case actually came out midweek last week. We were kind of late to the party, and sometimes that's a good thing because it gives us an opportunity to kind of slow down, take a look at everyone else's response, and then actually do a deep geek out on things. And that's what we've done here. And I really do gonna premise everything by, I believe that both sides, the Second Circuit, which authored this opinion, dead wrong. But then the reaction that a lot of people have, I'm not talking about the emotional reaction. They had every reason to be disappointed or angry or wherever they were. But some of their constitutional analysis may have been wrong as well. Okay, the case is Calce versus New York City. It is a challenge to two separate New York laws that ban the possession of electric weapons, stun guns, tasers, whatever you may call them. The laws in question are New York Penal Law Section 265.01 and New York City Administrative Code Section 10-135. The case was dismissed at summary judgment by the United States District Court for the Southern District of New York. The plaintiffs then appealed to a three-judge panel of the Second Circuit, which has upheld the summary judgment dismissing this lawsuit, saying there's no constitutional deficiency with this ban. Why? Well, simply put, they don't believe that the Second Amendment is in play at all. This is how they have ruled. Specifically, the court concluded that plaintiffs failed to provide any evidence that stun guns and tasers are in common use, and therefore, on the summary judgment record before it, no reasonable jury could return a verdict that stun guns and tasers are presumptively protected by the Second Amendment. Now, the Second Circuit gets it completely wrong when they actually announce what the rule of law is, because the court has ruled to determine under Step 1 whether the Second Amendment's plain text covers certain conduct. This court looks to whether the weapon at issue are weapons in common use today for self-defense, and whether the conduct at issue implicates the right to armed self-defense. Absolutely, positively the wrong test. But ultimately, I don't think that that was going to dissuade the Second Circuit from getting where they wanted to. They were going to uphold this law because they do use the terms in common use for self-defense or just in common use interchangeably. And we've talked about this phenomena where if courts really just don't want to get into the history, because there is none, they will often try to come up with ways to prove that the Second Amendment just doesn't even apply to the conduct at hand. And one of the things is that you just haven't established a record that something's in common use. We've even seen this argument with magazines and semi-automatic rifles. That was an argument also used here, leading the three-judge panel of the Second Circuit to rule. In other words, their submissions opposing defendants' cross motion for summary judgment were insufficient to establish that the weapons are in common use today for self-defense. And then in trying to establish that they were, in fact, in common use for self-defense, the court shot that out of the sky this way. The materials they cite are miscellaneous bits and pieces insufficient to establish that stun guns and tasers are in common use for lawful purposes. We have been clear that plaintiffs cannot rely on conclusory allegations or unsubstantiated speculation in opposition to summary judgment. Therefore, because plaintiffs failed to provide evidence that stun guns and tasers are in common use for lawful purposes, they have failed in this case to carry their burden at Step 1 of the Bruin analysis, and summary judgment in favor of the defendants was appropriate. And for that reason, this lawsuit remains dismissed. Now, a lot of people got really upset because, well, this is a disingenuous rule of law that they implemented. Absolutely true. And interestingly, when we take a look at Beckwith v. Fry, where they upheld a waiting period, saying, well, when we take a look at the text of the Second Amendment, it says nothing about buying or acquiring or obtaining a firearm, so the Second Amendment's not implicated at all. So when we can constrict our interpretation of the words, hey, that's the way to go. But when that doesn't work, then what we need to do is add words to it, such as in common use for self-defense, which is what the Second Circuit has done here. But to all the reactionaries, do you have every reason in the world to be upset about the ruling? Yeah, it's horrifically disingenuous. But many people rush to be Supreme Court experts and say, well, that's in complete violation of Caetano v. Massachusetts. Is it in violation of Caetano v. Massachusetts? Well, I think a lot of people overread what Caetano was and what it said. What a lot of people don't realize is Caetano v. Massachusetts, a case which struck down a ruling of a Massachusetts court which upheld a taser ban, was a per curiam ruling. The ruling itself is all of about 2.5 pages long. And while a lot of people believe that this made findings that stun guns were in common use for lawful purposes and therefore could not be banned, when you actually read Caetano, which we did, you realize that the lower court in Massachusetts had used a test which was so detached from reality, unmoored from constitutional standards, that the Supreme Court basically dissected their 3-part test, sent it back to them, and told them to do it over. Now, as I understand, Caetano ultimately settled out of court and there never was a do-over. But the points to be made in the incredibly brief per curiam ruling from the United States Supreme Court about what happened in Massachusetts were as follows. The court offered 3 explanations to support its holding that the Second Amendment does not extend to stun guns. First, the court explained that stun guns are not protected because they were not in common use at the time of the Second Amendment's enactment. This is inconsistent with Heller's clear statement that the Second Amendment extends to arms that were not in existence at the time of the founding. Then the court created this dangerous per se at common law and unusual test. Don't know where that came from, but the Supreme Court had to address that as well. In so doing, the court concluded that stun guns are unusual because they are a thoroughly modern invention. By equating unusual with in common use at the time of the Second Amendment's enactment, the court's second explanation is the same as the first. It is inconsistent with Heller for the same reason. And then, of course, the court also found that they were not readily adaptable for the military and therefore also not protected by the Second Amendment. That's right. The Supreme Court had to address that. Finally, the court used a contemporary lens and found nothing in the record to suggest that stun guns are readily adaptable to use in the military. But Heller rejected that proposition that only those weapons useful in warfare are protected. And then just a couple of sentences later, and the opinion is over, the Supreme Court stated, "The judgment of the Supreme Judicial Court of Massachusetts is vacated and the case is remanded for further proceedings not inconsistent with this opinion." And that's the end of Caetano. Now, did the Second Circuit blow it? Yeah, they totally blew it here. They blew it here with this in common use for self-defense, which candidly is just the injection of a balancing test back into it. But was the court's ruling in direct conflict, in direct violation, completely contrary to Caetano v. Massachusetts? Actually, when you sit down and read Caetano v. Massachusetts, which we've linked up down below, no, it's not. Okay, the case we're talking about today was Calce v. New York City. We're going to link up the Second Circuit's ruling down below so that you won't have to take our word for it. You can just geek out on it for yourself. Now, listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there. Tell us all about it. If you want to subscribe to our monthly newsletter, find out about all the cool stuff they won't let us talk about here, and meet all of our sponsors, there's a link in the description box for you to do that. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.